whatever you're saying here, you tell the judge by filing an IA, and if the judge passes an order, any order which is not agreeable to you, then you can come to the court. But in this manner, we can't entertain the writ petition.
This is regarding my child's fundamental rights because he's not been allowed contact with me from past 5 months. Apart from that,
You are putting it in a different manner.
My lord, there is an interim proceeding before the 5th Additional Sessions Court, Devanahalli. But my writ here is not challenging. There is a first order over there. It's page number 35. But here I'm not challenging any order or anything of that sort. This is regarding the fundamental rights of my child. Minor child who's 10 years old. And he has been denied contact with me. His
Filing a writ petition, there should be a relief from the court. Where is the relief?
there is no relief or any. I'm not appealing, ma'am. I'm not appealing your.
It's not about which is. No, there should be a prayer. How your writ petition is numbered?
Prayer is there, ma'am.
What is the
prayer?
prayer?
Is there, your lordship.
Writ of mandamus directing the respondent number 2 to facilitate visitation rights and meaningful access to the minor child for petition number 1, including on the child's birthday. That's not the way a writ petition is maintainable before this court.
Your lordship, it's been 5 months that I have not seen my child.
The procedure for that is, what are the pending proceedings?
Right now, it is mediations are going on, and I've been told that if I pay,
Mediation center. Some proceedings must have been initiated for what?
it is for restraining me from meeting my son. It's a GNWC case where the mother is seeking.
GNWC. So, in GNWC, you should have sought for the visitation, and when you have filed a petition for visitation, if the court is not entertaining it or passing any orders or passed any order, then you will come to this court. But with this kind of a prayer, a writ petition is not maintainable.
Your lordship, my son was diagnosed with mild autism. This was in.
No, that's true. But there should be an order. There should be an effort from you. Which court? You have to go to some court because
Yes.
we are not. This court is not having original jurisdiction under 227. You have to go before because there is a remedy before the family court where the GNWC is pending.
Yep.
There you file this petition saying that whatever you are saying here, you tell the judge by filing an IA, and if the judge passes an order, any order which is not agreeable to you, then you can come to the court. But in this manner, we can't entertain the writ petition.
Your lordship, this is not a custody. I'm okay with the proceedings
Not
that are going.
custody. I'm saying
But
visitation
visitation itself.
that you can ask.
This is regarding my child's fundamental rights because he's not been allowed contact with me from past 5 months. Apart from that,
You are putting it in a different manner. Now, either if it is before the court, you file GNWC telling that you would get the same relief, and you are trying to put it in a different way. But ultimately, your relief lies before the family court, not before this court.
Just one more submission. Regarding his health condition also, he was diagnosed with mild autism in the month of April. So I was denied any educational records or medical records also when I went to the school. So
All this has to be dealt with the GNWC court.
I have never denied any kind of maintenance or anything. It was rejected when I offered, and now it has
Why
been.
are you not going before the court? Why did you not file any IA for all these reliefs?
Right now, mediation is going on. I was told 9th of October, I have to file my written objections.
Written objections and also file your IA that, this is what you want, what you're seeking before the court. You ask the family court, not this court.
Sure, your lordship. I mean, like, if any kind of interim orders could be.
No, it can't be passed. It is, we can't exercise jurisdiction in that manner. Please come. The writ petition is filed, seeking the following prayers. When it comes to the petition submits that the wife had denied the petitioner access to the child. Access is the child is diagnosed with mild autism. The father has no contact with the child. According to the party in person, the fundamental rights of the child are violated. Hence, there shall be a direction to the mother to have meaningful access of the minor child with the father, including on the child's birthday, and to declare that filing of GNWC matter in the Sessions Court instead of the Family Court as improper and violative of the. It is filed before the Sessions Court.
Sessions Court.
Where is that?
6, your lordship.
Page number 6.
Page number 6.
No, it's not.
Page number 14, Annexure B.
Where there is no family court, the matter would be in the district court.
But Bangalore,
No, it's not in Bangalore, it's in Devanhalli.
Devanhalli.
Hmm.
Correct, ma'am. Correct, Your Lordship.
Hmm. There is no family court in Devanhalli.
Okay.
What did you write? That filing of the JNWC before the session court is a family court is improper and violative of the rights under Article 14 and 21. And also a direction to respondent number to the wife to ensure that all educational and therapeutic decisions regarding the minor child involve written consent of both the parties. Further, a direction to the wife to share all academic, behavioral, and medical reports of the child. The reliefs that are sought before this court cannot grant those reliefs while exercising the jurisdiction under Article 227. The wife had filed a JNWC before the courts at Devanhalli. Before the courts at Devanhalli. The father wants, as is yet to file his objections. It is stated that it is submitted that the matter is referred to the mediation. Once the matter comes back from the mediation, whatever are the reliefs that are sought by the petitioner father before this court, he can seek the same reliefs before the court at Devanhalli, before the court at Devanhalli, and the court would be considering the same and pass appropriate orders. The reliefs that are sought, the rights that can be adjudicated by the JNWC court, it cannot be, this court considering it as a violation of the fundamental rights cannot pass any order. Hence, the petition is
Your Lordship,
disposed
one
of.
more submission. One more thing is, I wanted to challenge the medical assessment itself about autism. It is mild autism, but it was given
That
with
can be
false
done
inputs.
and this court, hence the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. As no outwards orders are passed against the respondent, notice to the respondent is not necessary. Yes.
Petition.
Much obliged.
Yes.
Tell number.